Hello, welcome to the Virtual Hammer Museum, coming to you live from Los Angeles. I'm Claudia Besser, I'm the Director of Hammer Public Programs, and I'm pleased to welcome you to today's Hammer Forum on the recent Supreme Court decisions on government funding and religious institutions. Before we get started, I have a few notes for the audience. This program is being conducted via Zoom webinar, and in a Zoom webinar, we cannot see you in the audience and we can't hear you. We can just see your names and anything you type into the chat box and in the Q&A box. So we'd love for you all to introduce yourselves in the chat box and tell us where you're tuning in from. And the chat's also an area where you in the audience can all talk with each other. And the Q&A box is where you type in questions you have for the panelists. Please note that this program is being recorded and will be available later on the Hammer website. Also, if you'd like to receive reminder emails about our upcoming events, please sign up for our email list on the Hammer website. And you can also find recordings of most of our past public programs on the Hammer website as well. So now on to today's program. The Hammer Forum is a monthly series of public discussions about current social and political issues, and it's made possible with support from the Rosenblum family. And we're doing a special series within the Hammer Forum of Supreme Court, really important Supreme Court decisions from this year. So this is part of that series. So just 2 weeks ago, on June 30th, the Supreme Court decided the case Espinoza et al. Versus Montana Department of Revenue et al. It's a complex case, and although very specific to a special set of circumstances, the implications for the separation of church and state in the future are enormous. So we're going to get into the nitty-gritty of the case and then discuss the impact. And as a bonus, we've decided to add in 2 other Supreme Court cases that also deal with religion and the state. Little Sisters of the Poor, Saints Peter and Paul Home versus the state of California, and Our Lady of Guadalupe School versus Morrissey Baru, both of which were also just decided by the Supreme Court. We have 2 amazing constitutional scholars here with us today to shed some light on these cases. Professor Kimberly West-Faulcon holds the endowed James P. Bradley Chair Professorship in Constitutional Law at Loyola Law School in Los Angeles, where she teaches constitutional law. She's a graduate of Yale Law School, where she was senior editor of the Yale Law Journal. After law school, she clerked for the Honorable Stephen R. Reinhart on the Ninth Circuit U.S. Court of Appeals. She obtained her undergraduate degree from Duke University, where she graduated summa cum laude, receiving numerous academic honors, including the Duke University Faculty Scholar Award and the University Rankin Award for Constitutional Law. Her academic articles have been published in highly regarded law journals and publications around the nation, including the Journal of Constitutional Law, University of Pennsylvania Law Review, UCLA Law Review, and the Yale Law Journal. Professor West-Faulcon has also filed amicus curiae briefs in the United States Supreme Court based on her scholarly expertise and insights. Eric Segall is the Ashe Family Chair Professor of Law at Georgia State University's College of Law. He's the author of 2 books, Supreme Myths, Why the Supreme Court is Not a Court and Its Justices Are Not Judges, and Originalism as Faith. He's written over 40 law review articles and numerous essays and op-eds, and has appeared on CNN, MSNBC, and Fox News, among others, to discuss constitutional law and the Supreme Court. Our moderator tonight is Loyola Law School Professor Jessica Levinson. Levinson studies the law of the political process, including election law and governance issues. Her work focuses on ethics, political corruption, voting rights, campaign finance, ballot initiatives, redistricting, term limits, and state budgets. She regularly appears as a legal and political expert on television and radio and in print. She's the host of the new podcast, Passing Judgment, and has a weekly legal segment on NPR member station KCRW here in Los Angeles. She's also an op-ed contributor for NBC.com and the associate director of Loyola's Journalist Law School. Professor Levinson served as the president of the Los Angeles Ethics Commission until 2018, and she's also the founding director of Loyola Law School's Public Service Institute, which is dedicated to creating the next generation of leaders in government service. So hello and welcome, Kimberly West-Faulcon, Eric Segall, and Jessica Levinson. Are you there?
Hello. Yes, we are. I'm sorry for that delay. Thank you so much for having us into your living rooms tonight. So let me just start by saying thank you to the Hammer for doing this Supreme Court series. The Supreme Court obviously decides so many cases that affect our daily lives. And one of them, or three of them actually, we're going to talk about today. And they all deal with the bigger issue of religion and religious rights. And so when we envisioned this series, what we really picked out isn't necessarily which cases are quote unquote the blockbuster cases, but which cases affect you listening at home, watching at home, and hopefully to talk about what's on the horizon next. I also just want to say it's been really a highlight of the quarantine to do these and to see so many familiar names here on the participants list. So without further ado, what I'm going to do is briefly call up just a couple of slides. And the first, obviously, is just our topic today, religion in the Supreme Court. And then the second slide talks about the case we're going to start with. So we're going to focus, as I said, on three different cases today. Two of them deal with interpretation of the Constitution, and specifically the First Amendment, which protects religious freedom. One of them deals with a statute, which I'm sure many of you have heard of, the Affordable Care Act. So the first case really briefly deals with a Montana scholarship program. And the idea is that people could donate to specific groups that give scholarships to private schools and get a tax credit for that donation. The problem was Montana's constitution had a so-called no aid provision that said public funds can't be used for religious schools. The case gets fairly complicated from there. I think I'm going to let the panelists really untangle it, but there are three mothers who want to be able to send their kids to religious schools by using this program. They end up suing in federal court after a couple of twists and turns. And what they say is, my inability to be part of the scholarship program actually discriminates against me because I'm being burdened, I'm being discriminated against because I want to use these public funds for religious school. And what the court concluded is, yes, you're right. Your First Amendment rights are being harmed, the rights of the school and the rights of the parents or the families who want to send their kids to these religious schools. So that's the first case. Let's bring down the slide, bring back up our panelists. And Kimberly, West-Faulcon, let's start with you. Can you fill in some of the blanks? Well, first of all, let me say, a friend and colleague, I'm really glad that we can do this together. And how did the case end up becoming a federal claim? Because I found this to be one of the most complicated cases that we talked about this term.
Well, one, I want to say how appreciative I am to have been invited to participate tonight. I'm excited to have this conversation with you and Eric. And I have been anticipating these cases and these kinds of cases, not just for this term, but for the 3 years, I guess, since the court decided a case, Trinity Lutheran, that really started us down this route. So I was trying to think how I would synthesize if you asked a different question. I love that we're going to have an organic conversation, so everyone should know this is not like all set up and predetermined. It's going to be free flowing. But I guess before I launch into the details, I guess I want to give my overarching take, and it's kind of gloomy. Those who know me well know that's kind of where I am. I myself describe Debbie Downer when it comes to some of the things in constitutional law, although I think it was a momentous term. And if we were talking about the Title VII case and protection of the employment rights of people on the basis of sexual orientation, it could be a more upbeat conversation. But I find Espinoza to be a very ominous case for the protection of the line between the separation of church and state. I think it's an ominous case that sounds less ominous when you read it. I would recommend to anyone who is interested in digging into it, since it's very long. I would say if you really kind of want to understand what's going on, I think reading the last 10 pages would be very helpful, because that's Justice Sotomayor's dissent, where she kind of lays out what the problems are. Because if Supreme Court justices write their opinions well, which they're very smart people and they often do, the majority opinion always sounds pretty darn reasonable, right? If you don't know the backstory, if you haven't read the underlying cases. So I would say, in short, what is going on in Espinoza is also what was going on in Trinity Lutheran, that the court is taking compliance with the Establishment Clause principle, an Establishment Clause principle that some states have put into their state constitution, which is we're going to protect the line between church and state. And in a way that I think is problematic and disingenuous, transforming that into a free exercise clause violation. It's a labeling of something as discrimination, which isn't really fairly understood to be discrimination.
Let's step back for 1 second. 2 background questions. 1, what's the free exercise clause and what's the establishment clause? And then 2, what was Trinity Lutheran about?
Eric, do you want to take that one, or?
Sure. So hi, and thank you so much for having me. I'm just really thrilled and flattered to be here and to talk to Kimberly and Jessica. The First Amendment protects religion in 2 ways. The Establishment Clause says Congress shall make no law respecting an establishment of religion, and that the general principle there is the government can't reward religion too much. It also protects the free exercise of religion, and that's to stop the government from punishing religion. And there are many, many times when those 2 values are not in conflict, but there are some times when they are in conflict, and that's kind of part of the underlying problem. What I want to say quickly about this monstrosity of a case is when I was at the department, well, from 1946 to the mid-90s, the only issue the Supreme Court wrestled with kind of in this regard was what aid state and federal governments were allowed to give to parochial schools. Not that they had to give it, but what could they give? And I litigated that on behalf of the US Department of Education in the late 80s, early 90s. And the Supreme Court had come up with a bunch of ridiculous tests. Textbooks were allowed, but nothing else. But the issue was not, did they have to? What could they do? And this case changes all that. And what this case says is that if the state of Montana or the state of Georgia or the state of California wants to help children in private secular schools, which about like almost 40 states do, give them some kind of aid, let poor parents have a choice, then they have no choice but to give the same aid to religious schools. And this is tax money, our tax dollars, going to fund religious schools that we may or may not disagree with, and religious schools that are secular in nature, and in Montana, of course, they're all Christian. So so what Montana was trying to say was we don't want to be part of that problem of giving aid to religious schools. 37 states have basically said that, and the court, in a general way, and the court made up this rule from Trinity Lutheran 4 years ago out of whole cloth. So I want to end that monologue by saying this. If there are any people out there who think this court is an originalist court, originalism is the big, tag word of the day for the Supreme Court. This is living constitutionalism at its zenith. I litigated the Establishment Clause cases with the lawyer for the United States Catholic Conference, who was a very famous lawyer. Nobody thought that the question was, did the states have to give the aid? The only question was, could they give the aid? The Supreme Court has changed that based on nothing in the original Constitution and based on their own values about, and this is about religious freedom. This is about disarming states from trying to not lower the wall of separation of church and state.
Okay, but tell us what you really think about the case. Don't hold back. All right, so I laid out briefly the facts of the case. We said that there were some twists and turns. We said that the court was looking at the precedent of Trinity Lutheran. Then I asked the question that I should have asked in the beginning, which is, tell us about what the Establishment Clause is and what the Free Exercise Clause is. Kimberly, can we go back to you? We keep saying this Trinity Lutheran case, it's about school playgrounds. Can you remind us a little bit about what that case was? Because it helped the court, obviously, it guided the court's decision in this case, in the Espinoza case.
Yeah, I'd be happy to. The big picture is that in addition to the US Constitution having the religion clauses that both prohibit the government from essentially having state-sponsored religion. And people probably have a decent intuition as to why in a pluralistic society like ours, where you have people who are non-religious, people who have various religious beliefs, we have majority religions and minority religions, that it fits with keeping our nation a free nation to avoid having a state religion. And so that's kind of the basic principle of the Establishment Clause. I mean, really making it very, very basic. But at the same time, it's also a nation that it also makes sense to have a provision in our Constitution that protects the free exercise of religion. That you can, if you do ascribe to a faith, that you can do so without being persecuted by the government. Again, just kind of big picture. At the same time, we're also a nation that permits dual federalism in the sense of we have dual sovereigns. We have our federal law and we have our state law, and we have a federal constitution and we have state constitutions. And various state constitutions also have put within their constitutions those same principles. And so the backdrop of Trinity Lutheran is that if that had been a question that had gone to my constitutional law students, the question that was put forth to the court was a program that provides funds to renovate a playground. Can those funds go to a church preschool? And before Trinity Lutheran, that would have been a very straightforward answer, because as Eric was saying, it has been the longstanding precedent that when you don't give money directly to churches to avoid the government getting entangled with the church. It's not to mistreat churches. It's not to pick and choose amongst churches. It's all of those reasons that maybe it's a mosque, maybe it's a synagogue, that there's in general a desire to have a separation of church and state that protects us all in various ways. And so it was absolutely unprecedented to have the court conclude that Montana, I'm going Montana, Trinity Lutheran, but Montana is what happened to Montana here. But in Trinity Lutheran, it was absolutely unprecedented for the court to say that the failure to give money to a church violated the church's rights. And so, it was essentially saying that the state's effort to comply with its own protection of separation of church and state was itself a violation of the Free Exercise Clause. So it took the two clauses and really reversed them. It complicated the doctrine in a way that ultimately makes it possible to now have this case, which transforms compliance with a principle that keeps us all in a pluralistic society where, again, the government doesn't tell us what to do one way or the other, and now creates confusion and I think an ideological opportunity to divide the nation even further by labeling something that was, again, something that was supposed to protect us all. Like whether you're a Baptist, you're Jewish, whether you're irreligious, whether you're part of the Humanists, you do not want the government bossing us around. There's nothing more American than that. But the way the court has opted in Trinity Lutheran, and in this case, to use very incendiary language, bigotry, to reference the Ku Klux Klan, to reference discrimination, to say that this is being done solely because of religious status. It's very difficult, I think, for someone who isn't very steeped in this jurisprudence to have any idea what's going on. And I really fault the court for that, because I think they are, first of all, public servants, but there should be an obligation to make it more clear when they are doing what they're doing here, which is they're changing constitutional law in a very significant way. And I think that's what Eric was getting at. We can talk some about their form of original meaning originalism and their form of textualism. I look forward to that. But big picture, it was the first time in Trinity Lutheran that the court held that a state had to give money to a church, plain and simple. And before that, there had been a principle that if it was something more generally applicable, like fire services, police services, then indeed a church would be covered by those sorts of activities. But that if you gave money directly to a church, you were, in a sense, funding religion, because money you don't have to spend renovating your playground, you can spend buying Bibles. And that very delicate balance between free exercise and establishment had been working very well on a case-by-case basis. And these two cases are really shifting that balance.
Yeah, so the punchline is kind of, I think, a weird one and not an intuitive one for people, because we have the First Amendment and then we have these two provisions that protect, really, as Kimberly said, are intended to protect all of us, whether we're religious or a-religious. We have the Free Exercise Clause, we have the Establishment Clause that we shouldn't have a state religion. And then we have state constitutions, and we have, I believe it was 38 before this decision, state constitutions that had these no aid provisions, which in its simplest form essentially say, don't provide public funds for religious schools. And what we have then in the Trinity Lutheran case, what we have then in the Espinoza case is a court, I hear you both saying, kind of turning the basic ideals on their head and saying, if you have a program, and I think it's worth emphasizing this, if you have a program that's state funded and it benefits secular schools, you have to have the same program for religious schools. That, it seems to me, would invalidate the state constitutions of, at least provisions of the state constitutions of 38 states, and would upend the way we create these public scholarship programs for schools. Now, Eric, tell me if I'm overstating this.
No, you're understating it, actually. And the reason I feel so strongly about this case is you didn't act. The plaintiffs in this case were parents, but they didn't bring the case. And this is very important. This was a case brought by a group called the Institute for Justice. And the Institute for Justice, which is a public interest organization for a certain cause, I'm going to say this, and I'm really not overstating it. They're going to destroy public schools. And their mission is, one of their many missions is to destroy public schools. And so what's coming next, so I want to get on the ground now. Let's leave law aside. I think everyone listening will sympathize with this. There's going to be a challenge soon to a state where they're going to say, you spend X number of dollars, millions, on public schools. And public schools are by definition secular. By definition, there's no religion in the public schools. If you do that, you have to spend the same amount of money per capita on religious schools. That lawsuit is coming. And that lawsuit would have been unheard of before Trinity Lutheran. And it is a lawsuit that I hope will lose, because it's hard to imagine. My test for constitutional law is, can you imagine a New York Times headline saying the result? And it's hard for me to imagine a headline saying states have to fund private schools to the same amount they fund public schools, but they're going to try to do that. They are. And in 1990 or 1970 or even 2005, before Robertson and Alito took the bench, there's no way. This lawsuit would have been laughed out of court. So it is unprecedented. It is important. And it does disable state parts of state constitutions in 38 states, 37 or 38 states. You would think the conservatives, this was a 5-4 opinion, conservatives versus liberals, you would think federalism would come into play a little bit for these conservative judges. It did not come into play at all. This is a major case.
Briefly, if federalism came into play for those of us without law degrees, what would that mean? Well,
federalism suggests that unless a state clearly violates the Constitution, which they can't do, then we're going to leave states alone to experiment. Justice O'Connor was very big on this, that states should be laboratories for different methods and ways of financing things and all of that stuff. And 38 states didn't want to give money to religious, not just schools, religious institutions. And there was a case prior to Trinity Lutheran where Washington State, this case is Locke versus Davey, Washington State had a scholarship program that basically excluded people studying for the ministry. Supreme Court upheld that 7-2 with Justice Rehnquist, who was as anti-establishment clause justice as we've ever seen, with Justice Rehnquist writing the decision saying, when we balance free exercise and establishment, we're going to give states leeway to make that balance. We're not going to force them in a certain direction. That's federalism. These justices didn't do that.
Kimberly, self-described doom and gloom.
Well, can I interrupt you, Jessica, and just try and give another go also at what's going to happen next? Because
that's what I wanted you to do.
While Eric has given the big picture of what the future, maybe I'll need to be whatever the opposite of a Debbie Downer is. I don't usually have Eric with me to give me my doom and gloom. So maybe I'll just try and be, okay, well, maybe it's not going to be so bad so quickly. This is great. We should be together more often. But as Eric has pointed out, you have impact lawyers on one hand who are bringing cases to the court with an agenda to change the meaning of these provisions of the Constitution. But you do still have a court led by a Chief Justice Roberts, who is an institutionalist and who will ultimately try to present this as an incremental shift. So what we're trying to get past tonight is we're not going to be here all night. So we want to let you know that as incremental as it may seem in the abstract, this is really a very big deal. But I know there are probably some people who are as wonked out and constitutional law geeks as I am, who are like, but I want to really know exactly what could happen, like tomorrow. And so if you heard probably one of the justices in the majority explain this case, what they would say is there's a little bit more going on as far as we're a far cry from what those two law professors are saying could happen right away. And the way they would present that is to say that, well, first of all, this is something that was going on in the Montana tax code. And so it is that Montana was allowing this tax credit, and it was allowing it if you donated for a non-religious school, but you didn't get the tax credit if it was for a religious school. Then the Montana Supreme Court ruled that violated Montana's own constitution, because it constituted, when it was in place, it constituted giving money to religious schools. So what the Supreme Court would say, and the majority said they were doing, is that they were simply essentially reversing the Montana Supreme Court's ruling, and that they were going to leave it to Montana to figure out what to do. So right now, the court could say, well, we don't know exactly what Montana will do. But as Eric is pointing out, it's absolutely true that what this is going to stand for, the proposition is going to stand for, and is going to be that you need to be very careful, state legislature, if you provide any sort of program to a non-religious school, a non-religious institution, and don't provide the exact same option to religious institutions. And how quickly that will come to bear will depend on what's going on in these state legislatures. So I think it will be a matter of time to see how this all plays out. But we do have justices on the court, like Justice Thomas, who have put themselves squarely in the category of, I care not about precedent. And my interpretation of the Constitution is that I think the government actually can sponsor religion. Those are the things that kind of make my eyes pop out of my head. I'm like, and Justice Thomas's view is that as long as the government doesn't coerce you to pray, then there's no problem. And that's even a far cry from where we are today. And so what is striking is how this court is really very, I would characterize it as very a judge-empowered approach to interpreting the Constitution, that they present themselves as, Roberts in particular, we just call the balls and strikes. But when you dig down into this case and the other two religion cases, you see a very judge-empowered court, and very activist, very willing to change what we learned in law school provisions of the Constitution mean. And as we teach our students now and imagine what it'll be for 5 years from now, it's going to be a very different, they have very different meaning.
Well, Eric, I know you're going to have a lot to say because you wrote a book on this, Originalism as Faith. And but I do want to get into, Kimberly just talked about, there are two other cases, and specifically there's one other. Let's stay with the Constitution and let's stay with schools. And there's another case. So if we could bring up the slide really briefly, it's actually the next slide. I'm taking it out of order a little bit. So the very quick overview is that there were two elementary school teachers at Catholic schools here in Los Angeles, and they both wanted to sue their schools after they were fired. One allegedly fired based on age. Another allegedly fired because she told the school she was undergoing breast cancer treatment. And the court said, no, you can't sue under the First Amendment because the First Amendment has this thing called the ministerial exception. And let's bring down the slide, please. And the ministerial exception, as I understand it as someone who doesn't teach in this area, essentially says, Catholic school, we want you to have enormous power to determine who teaches the faith. We want you to be able to determine frankly, the way the decision reads to me is that if you're a Catholic school and someone who works for you is considered a minister, even if that's not their title, meaning if they're a school teacher, but they're teaching the faith, then you can fire them and you can ignore federal anti-discrimination laws. Eric, I think Kim had the last word before. So is that too blunt force of a description, or are religious schools now empowered to really violate federal anti-discrimination laws?
Yeah, it's not blunt enough, actually.
Again.
Sorry. So let's all agree on something. I think everybody who's here virtually, and we can all agree that the government cannot tell a mosque, a synagogue, or a church who their rabbi and ministers are going to be. And the federal anti-discrimination law would not require a temple to hire a priest. So we all agree on that. Now let's go one level down, though. The Congress of the United States, who represent, in theory, the people of the United States, have passed anti-discrimination laws that apply to schools that say, among other things, you can't discriminate on the basis of course, gender and religion, but also age and disability. And those laws apply to everybody. Now, the question is, should they apply to religious schools? And until 8 years ago, they did. And again, about 8 years ago, the court has kind of made up. By the way, you called them judges or bad. They're not judges at all. But that's a different conversation. We shouldn't think of these people as judges. That's not what they do. And
that's Hammer Forum Part 2. Later, sign on at 6:30.
And these two cases show that. So the court made up this ministerial exception, which I do think comes from the Free Exercise and Establishment Clause, and then extended it to basically, essentially, all teachers in all religious schools, overriding Congress. So here's the point I want to make. When do we want the Supreme Court to override Congress? And in my opinion, when Congress clearly violates the Constitution. But that's the only time. This case does not involve that. Congress is allowed to protect teachers. Generally, the statutes at issue were not about religion. And one more thing. If they were fired because they weren't teaching the faith correctly, then we could have a different conversation. But the schools didn't allege that. They were fired for secular reasons. There's no reason why these teachers shouldn't get the benefits and protections of the same employment discrimination laws that people across America get.
Kimberly, to the optimist in the room now, the comparative optimist in the room, there was another, I want to stay with, so we're staying with the Our Lady of Guadalupe case. We're staying with the ministerial exception for a second. And there was another case that came out this Supreme Court term that was a blockbuster, the Bostock case, which dealt with Title VII of the Civil Rights Act. And in its simplest form, what that court asked in that case is whether the Civil Rights Act, which says you can't discriminate in the workplace on account of sex, does that word sex include discrimination on account of LGBTQ status? And Justice Neil Gorsuch said, yes, it does. And for reasons that we can do a whole, other few hours on. But it seemed to me then that under federal law, you are protected from workplace discrimination based on account of LGBTQ status. Eric is nodding his head, but shaking his head no. How does that interact with this case, which says, if you're working for a Catholic school, even if you're not teaching the faith, even if you're not a minister, we can fire you if we want because of your age or because you're undergoing medical treatment?
Yes, so it is the court giving on one hand and taking away, like, we didn't even get a month, right? Like it was something that people who were court watchers could anticipate. And to give my effort to encapsulate Our Lady of Guadalupe, and also, desperately trying to take what is 3 complex religion cases and say, oh, can we put this in a digestible form? If we just talked about the case that was creating religious discrimination where there was none. Where if the last case, Espinoza versus Montana, is the Supreme Court saying that being religion conscious is itself religious discrimination. And let me put a little asterisk there and go, okay, this makes me scream, because when it comes to actually identifying what constitutes actionable race discrimination or sex discrimination or sexual orientation discrimination or any other kind of discrimination, the Supreme Court's standards for what constitutes actionable discrimination that triggers its highest standard of strict scrutiny is really, really crazy high. But now, after Espinoza in Trinity Lutheran, even being conscious that a religious organization is a religious organization or a religious school is a religious school, we've got 5 justices willing to label that as bigotry. Really trying to play on what is hopefully our moral objection to those other kinds of discrimination. So that's a case misusing discrimination. And then what this case is it's a right to discrimination case. And sadly, the US Supreme Court has been doing this. You know, I've got my 1883 case that was one of the early versions of, you know, we have a right to discriminate if we are in power, if we are the group who has all the rights, that if you take any of our rights away, it is violating our right to be discriminatory. The court's got a long history of those. The court has stood up against that kind of argument in a case, Romer versus Evans, that involved sexual orientation minorities. But here it is creating, and I don't have a problem with judge-made law. I mean, the court managed to end one of these opinions with a Marbury versus Madison quote. And of course, what the court says the law is, the law is. But what this amounts to and translates to is saying, on one hand, in that first case, don't treat us, if you treat us any differently as a religious organization, it discriminates against us. But in the other 2 cases, it's we get to be special and get special treatment, and we are exempt from otherwise generally applicable laws. And that's also a big change in law. When I was in law school, when it was a religious minority, and this is where I would engage with Eric about, well, when is the court supposed to step in? There was an old school view, and we don't have a majority of the justices who believe in it, but an old school view that you stepped in when the group that was being impacted couldn't use the political process to protect themselves from the majority. That some of you may have heard of the phrase discrete and insular minority, a case Caroline Products and its famous footnote. But the idea that we want judges to at least purport, and I agree with Eric, there's some challenges about it, but justices purport, they're not legislators. They purport to do something else. And for many decades, what we at least told ourselves they purported to do was they stepped in when the mob rule of the majority would harm a group that was never going to be able to garner protection from the majority. Where this has gone awry is that when you look at these 3 cases together, Justice Alito's inclusion of cartoons aside, which I find that very interesting, right? And his references to the KKK aside, this is ultimately using the First Amendment to confer on religious organizations the right to discriminate, as you laid out, on the basis of, with Title VII now, that would be race potentially, that'd be sexual orientation potentially, sex. Religion, there is an exemption for religion. You can take into account religion in picking your minister. You can take into account religion in picking your religious teacher. But this is saying that you get a pass on engaging in age discrimination, disability discrimination, and the analysis used, while it doesn't explicitly say in the case, this also applies to Title VII. There's nothing in the logic, as the dissenters say, that would distinguish it. So it's an invitation for a church or a religious school to fire someone because they are in a same-sex relationship, they are gay or lesbian, and bring this back to the court and have the court apply this not just with age and disability, but to apply it with respect to employment discrimination on the basis of either race, sex, or sexual orientation.
All right, Eric, you Justice Alito'd me by vigorously shaking no while I was talking. So I just want to, again, because I know these become really weedy topics. Kimberly, what I hear you saying is in the Espinoza case, the court concludes as a matter of constitutional law that or what I hear both of you saying is that it is discriminatory if you have a public program that provides, for instance, scholarships. It's discriminatory if you don't treat secular and religious schools the same way. And then based on Our Lady of Guadalupe, we have a situation where religious schools are free from the constraints of basic laws that prevent discrimination against other people, and in some cases against religious people too. So Eric, I do want to move on to Little Sisters, but I want to give you your moment to explain why you alitoed me.
2 quick points, one small, one big. The small point is in the Title VII case itself, Justice Gorsuch wrote a few sentences about how this might not apply to religious schools. We know where that's heading unless the people on the court change. That's the small point. I am going to be Mr. Doom and Gloom and say to Kimberly that I wrote a whole book that the thesis of which was mostly over time the court has hurt minorities a lot more than it has helped minorities. The Warren Court lasted about a decade and a half. And then,
I want to give the opposite, right? I want to not.
Yeah, I'm sorry, but I mean,
yes.
So let me just give Jessica. Let me just give one example that people probably don't know about, but it's so important, and it's not related to religion, but it's race, but it's so important. In the 1870s, Congress actually passed a law prohibiting race discrimination in restaurants and theaters. Congress was the Republicans. They were Republicans at the time in Congress were trying to stop Jim Crow before it began. And the Supreme Court overturned that. And then the Supreme Court blessed Louisiana's segregation law. So with only a few exceptions, if you look from 1788 or 1803 till today, with the exception of about 15 years of the Warren Court plus Justice Kennedy's gay rights opinions, with the exception of that, minorities have been hurt by the Supreme Court much more than they've been helped. And I just wanted to, that's my opinion. And I did write a book defending that proposition.
And I'd love to agree. And I want to say thank you, Eric, because now you're letting me go to that 1800s case. We're talking about the same 1800s case. And so what I'd say, again, I'm sorry for someone who is hoping for more optimistic folks tonight, right? Which is that's what we're seeing here with this case that I'm saying is a right to discriminate case. That the case you're talking about is the civil rights cases. I tell my students we should just call them the anti-civil rights cases because it's just confusing as all get out. Because what the Supreme Court is doing, it's overturning a public accommodation statute that's saying Black people can go to the opera. But the perversity of it is the Supreme Court uses the same kind of reversing language that is going on in these religion cases. Because what the Supreme Court says is, not only are we going to strike down the civil rights law, we're going to tell Black people, it's time you stop being the special favorites of the law. It really resonates in a modern critique of affirmative action and Black people wanting preferential treatment. And the perversity of that when we're dealing with the Reconstruction era. So you're absolutely right. There was only this Warren Court period where anyone could purport that the Supreme Court was stepping up for discrete and insular minorities. But we still have, and she's back out of the hospital, right? Ginsburg, there are a couple of people on the court who at least would tell you that's what they see as their job. But Jessica, this is a good way for Eric and I to kind of move to where I think we both want to go, which is that this is a court in the way I describe it. And but I completely agree with everything that that Eric has written and described, and we just have different ways of labeling it. This is a court that the majority of the court does a good job of creating labels for how it interprets the Constitution and statutes that make the average person think they're very constrained. Like to call something originalism, to call it original meaning originalism, or to say I'm a textualist, sounds like I'm just pulling back and letting the words do their work or letting the Constitution do its work. And what digging down into this really reveals is that they don't believe in originalism the way Joe Q. Public or your friend down the road would think that originalism should be followed. What they really do is they say, we don't care what the people who wrote the words think. And that's very counterintuitive. But if you dig into these cases, that's true across the board. Their version of originalism is I have my own dictionary. Some are very old, some are very new, and I use them when I want them. And then I can tell you what the Establishment Clause has meant, even though that would mean that my students will have to throw out their con law book possibly in 5 years. That's how they do it. And when it comes to textualism, and I'm going to maybe do you a favor, Jessica, and transition into the Affordable Care Act case. When it comes to interpreting a statute, they do the same thing. I don't care what the people who wrote the words meant. And that's not what the person down the road or my neighbor would think. They'd be like, oh, well, maybe I would care what Congress thought. But no, I'm a judge. I'm an empowered judge. I will pull out the dictionaries around me. And if you pick up either one of these, they're textualism cases, a lot of cites to dictionaries. Which dictionary they get to pick, we don't know. I mean, but they actually write a book and say which dictionary and which word. But the reality is that it's a very judge-empowered, justice-empowered approach to telling us what the text of a statute means. And while we should move into the details of the Affordable Care Act case, my big picture point would be that this court doesn't do a very good job of hiding its agenda. It is not doing a good job for those who read the cases. And I would invite those who are listening tonight to geek out a little bit with us and read into it, because you can start to see that things that sound very constraining, like textualism and original meaning originalism, aren't very constraining at all for this court.
One quick point, really quick.
Yeah.
Erwin Chemerinsky, who was at USC for many years and then is dean of UC Irvine, now is dean of Berkeley, said it all in a Harvard forward in 1986. And this is true for statutory interpretation and constitutional law. The decisions of the Supreme Court from 1803 until today are nothing more and nothing less than the aggregate value preferences of the justices. And that's what he said. I agree with it 100%. And the value preferences of these justices is to put the free exercise clause way above the Establishment Clause and to say we can favor religion pretty much to a significant degree, but we can't do anything to hurt religion. And that's not what the First Amendment originally meant.
Eric, tell us the titles of your book, because we're not going to be able to have a full discussion of
well, actually, my two books actually intersect the points Kimberly made so beautifully.
I know.
One is called Supreme Myths, Why the Supreme Court is Not a Court and Its Justices Are Not Judges. Now, if you want to say it's a court, but a terrible court, I'll live with that, but it's really not a court at all. Listen, giving unreviewable power for life to government officials is the worst idea any democracy has ever thought about. No other country in the world does it. And by the way, Jessica, if you or Kimberly or I had unreviewable power for life, we would do what we wanted to do and wouldn't care about the law either. Because that's one. Two, originalism as faith. And the reason I said that, Kimberly, I mean, you might be interested in this. The reason I use the word faith is because I don't need to impute bad faith to Thomas, Scalia, Gorsuch, and the legal academy that says they believe in originalism. I believe they believe it, but it's irrational. That's why it's faith, because nothing that happened in 1787 or 1868 can tell us today how to deal with LGBTQ issues, drone strikes, federal agencies that didn't exist at the time. We could go on and on and on. And the reality is they don't use, as Kimberly said, they don't use originalism. They don't use textualism to decide cases. They use that as the rationale for the long-winded opinions that they write. But the reason Justice Thomas has taken the public position on a number of occasions. The Establishment Clause doesn't apply to the states. So state of Georgia could have an official state religion. Now, they couldn't put me in prison for not being Christian, but they could have an official state religion. That's an insane view. And what Thomas's view is not originalist, it's his preference.
Eric, I just want you to have stronger opinions throughout the rest of the panel. And all right, with that, Hammer folks, can we call up the very last slide quickly? This is a case called Little Sisters of the Poor, a group of nuns, I believe. And what it focuses on, again, is the Affordable Care Act. And I'm going to give the really broad brush summary, just so we all get on the same page briefly, which is that the Affordable Care Act essentially says to many employers, based on size, you have to supply health insurance plans that provide women with preventative care. The regulations say preventative care includes contraception free of charge, no cost sharing. Some employers, namely certain religious employers, were exempted. And this case is about the Departments of Health and Human Services, Labor, and Treasury trying to expand out that exception and trying to say it's not just for certain religious employers, it's actually a much broader exception. It's for employers who have a sincerely held religious belief that they do not want to provide this contraception, or it's for employers who have sincerely held moral objections. The court, the punchline is that the court concluded that the departments could blow out this exception and could include many more employers who do not have to provide health insurance programs that provide free contraception. With that, if we could bring the slide down for a moment, let's remember, we all love geeking out on law. Let's remember what this means. It means for tens of thousands of women that they will not have the access to contraception that they did before. It means, as Justice Ginsburg said, from the hospital room when these, I believe, when these oral arguments happen, doesn't this mean that many women will now have to go through some other government program or administrative burden to try and have access to healthcare? So we always try and make sure, I love the legal discussion and also explain why these cases matter for people. If you're teaching in a religious school, these cases matter. If you're a woman who obtained free contraception through your health insurance program, these cases matter. And so, Kimberly, to you, how did the court, this is our first statutory case. Our first two cases were constitutional cases, meaning it was, the court was making its decision based on a federal law, not the Constitution. How did the court arrive at its decision that this exception could be expanded out? And how is it making that determination in the first place?
So happy to do that. I do want to geek out though about how we characterize the case. I said it was the right to discriminate case. Those were statutory cases to the extent that the women who were deemed to be, whose jobs were deemed to fall into the ministerial exception, right, they were teachers who were alleging they weren't ministers, that they were different from the teacher who was more of a ministerial teacher, and they had employment discrimination claims that they brought under federal statutes, and how the employer essentially nullified their attempt to vindicate their rights under those federal statutes was to rely on an interpretation of the First Amendment that the Supreme Court did interpret into the Constitution. So where there's a similarity and where I can transition is trying to take on my new role, and it's a tough one, to be the optimist in the Zoom room. I would encourage everyone who's listening to us to see that there is an opening for a Congress and the majority to have some sway and some power that is separate and distinct from the power that these people who have their jobs for life have, because of the very specific way it seems like a majority of them have purported, and I use purported very carefully. Eric, I get it. What they say they do versus what's in their heart and soul or their conscious minds. That's a complexity. I tell my students, when you're litigating, you can't really figure all that out. But on the page, they say, and Gorsuch is our quintessential example, Jessica. That's how we get his vote in this Title VII case. He says, I'm not going to go and try and figure out what Congress's purpose was, which is how he works out the Title VII employment discrimination case, because if you went to the purpose of those who were enacting that employment discrimination law, when they were thinking of the word sex, they were not thinking of sexual orientation. But how you get Gorsuch's vote is he's like, I care what the words say. Right. So when it comes to the Affordable Care Act and whether or not the contraceptive mandate is going to apply, and whether or not an agency, these various departments and the executive branch, have the power to delineate who does and doesn't have to comply with the contraceptive mandate, that opinion is a lot about what are the words? What are the words in the statute? And so what you have this court saying is, we have parsed and gone over all the words, and based on those words, the Trump administration can come in and say that these groups don't have to comply with the contraceptive mandate. So how do I get to something that's optimistic? Well, if you get a Congress that is willing to put more explicit and different words into a statute. Now, I know that requires a Congress that actually can pass a law and a president that can sign it, but there is a role for we the people, because the majority doesn't always have to act like a mob, right? The majority can be in favor of laws that have a contraceptive mandate. The Affordable Care Act could have had and could have a more explicitly textual delineation of what kinds of health benefits you have to provide, and some specifics about what kinds of organizations are exempted. But how you got Justice Kagan's vote, because this is one of the 7-2 cases, you get Justice Kagan going in and saying, well, when I read the text, I can't, I can see it two ways, right? And since I can see it both ways, I defer to the agency. So who runs the agency? Who decides who's in the agency? President Trump. Who decides who's in the White House? The voters, right? So when it comes to a statute, I think the big picture point is statutes ultimately come from the majority and from the people, because we send people to Congress who can pass new statutes, they can repeal the ones that are there, and that this particular administration is what is pretty what needs our focus, because it's the administration and the Trump administration that opted to broaden this contraceptive mandate beyond religious organizations and religious objection to simply moral objection. So there's not a lot of clarity as to who that limits, and then saying it can be private corporations, and so companies that are closely held, but still they're not religious organizations. So you get an exception that's starting to swallow the rule. We have a contraceptive mandate, but it's not mandated for many entities anymore.
Eric, I have two things that I really like you to help us with. First, please bring us down. That was way too optimistic. And second, I think it's time now to wrap up the cases and take where we think the court is going. But I think you actually said in the beginning, and I want to give you a moment to talk about it, that as a policy matter, you're not a fan of Little Sisters, but as a legal matter, am I correct that you said that you think the court got it about right in this case?
Well, let me be crystal clear. I don't have a strong opinion about this. It is actually a very complicated administrative law case. And actually, it's being remanded to the lower court for even, so when I say administrative law, what I mean by that is, did the Trump administration go through all the right hoops to change what the Obama administration did? And that turns out to be a very complicated question that is unconscionably boring, and we don't have to go into that. I agree with Kimberly 100%. In the first two cases, the court was really a wrongdoer, in my opinion. The court did make things up out of nothing that hurt the American people. In this case, I think the court reached the right decision. It's the Trump administration that's really the problem here, and Congress to some degree. So all I want to say about this is I would like the American people to find a way to get enough people in the federal government to require employers to provide contraceptive insurance, because our insurance program is through employers, unfortunately, to all women who need it. That will help those women. It'll help society. The problem of unplanned and unwanted pregnancies is one of our society's biggest problems, especially in populations of color. And I hope we do that. And if we do that, there's nothing the Supreme Court can do about it. At least even I think that if we can get a law that requires contraception coverage, there's nothing the Supreme Court can really do about that. I really hope, I agree with Kimberly 100%, this is an issue for the American people to change. You asked me a second question. As far as all three cases go, I do think that we shouldn't be faked out by the Little Sisters of the Poor name. Again, this is public interest litigation, and there's nothing wrong with that. The NAACP brought Brown versus Boyd. I mean, it's good for the right, it's good for the left. But let's be clear. What the Trump administration is doing is allowing businesses to opt out of an expensive thing for almost any reason they want to. And that's not in the interest, I think, of women and the American people. Let's get in a new Congress and a new president and change
Which reminds us, everybody listening at home, it's a good time to make sure that you're registered to vote. It's always a good time to make sure during COVID that you, if you can, have a vote by mail ballot. And this is going to be my 20-second soapbox, which everybody signed on has already heard me say. Please feel very comfortable with the vote by mail system. There is not systemic corruption in our elections. There are plenty of election administration nightmares. There are plenty of problems with our elections, but the idea that people should feel uncomfortable with voting or voting by mail is simply incorrect. And so I apologize for that aside. And so I'm so glad that we did this, because it does seem to me increasingly like the big questions coming before the Supreme Court are some version of religious rights versus fill in the blank. So religious rights versus the freedom from discrimination, religious rights versus I don't want to have to provide contraception. And so Eric, I think I kind of gave you a little bit of short shrift before, so let me stay with you for this one. What are the big cases coming up dealing with religious rights that for Hammer viewers will affect their lives, will affect where they can send their kids to school, whether or not their kids' teachers can be discriminated against, whether or not they can, obtain contraception coverage? What's coming through the system?
I want to repeat what I said earlier. As far as I can tell, public interest litigants on the right have one major goal in mind when it comes to education. And I know this is a terrible sounding sentence. They want to destroy public schools. They think that just yesterday, a very famous law professor named John McGinnis at Northwestern Law School wrote an essay explaining to his readers how public schools are just left-wing instruments of propaganda. And he said the Espinoza case is a fantastic tool to use to sap public schools of money, of funding, of their importance. So that's one big issue that's going to go slowly. And hopefully we have a new Supreme Court by the time it gets there. One with a Democratic president, but nominating people. But I think there's nothing bigger than that, because I believe in public schools. So, that's a big deal. One other big deal that doesn't sound big, but I think it is this court in previous terms has upheld a practice of having consistent Christian prayers at legislative sessions where people have to go to do public business. And so you have people sitting in a room in a legislature, and someone says, stand. Now they can't make you stand, but 9/10 of the room stand, and you don't stand. And then they say a Christian prayer. And then you ask your local town or municipal legislature for a law, but you didn't stand up. Well, that's bad, and they're not going to like you. Supreme Court shouldn't allow that. There shouldn't be religious prayers at government sessions. But this court has been very clear. They can be prayers, they can be all Christians. And I do think that has significant impact on people in real life, on the ground, who go to their town bodies and ask for laws. So those are the two things I'd say.
Kim, being the sunshine on our parade today, what else should we be, maybe this is the point where you just can't keep that roll going. What else should we be thinking about? Eric lays out two fairly troubling topics. So is there anything else we should have our eye on? And then we have a couple of questions that I want to get to.
Okay, let me try really hard on the sunshine piece. The sunshine piece, because I think it was the second to last time I did a Hammer event, and it was in person. One of the questions I got was, what keeps you up at night as a professor of constitutional law? And it was none of the things we just talked about. It was tyranny. It was worries that the nation would become, and I think the second time I did something in person after that, it was like, I worry whether we will continue to live in a free country, because we have a president who does not understand the Constitution, doesn't understand checks and balances, wants to be a tyrant, and says Article 2 gives him unlimited power. So sunshine even though they weren't the cases that we talked about tonight. I was very grateful because I am almost as cynical as Eric, and maybe I am as cynical as Eric. I just have to figure out some way to translate it into doctrine from time to time, and so I may sound not quite as cynical, but maybe I truly am. But this court did write down that we don't have a king, so I think everybody should see that as good, and I hope they'll stick to that in the next term. But that's about all I have when we're really focusing on tonight, because tonight's cases are cases that I would say demonstrate what I have seen coming, maybe since I was in law school, which is that even if the court were willing to interpret provisions of the Constitution to give greater rights in areas where people have been historically oppressed, misogyny, structural racism, homophobia, discrimination against those who have historically been the victims of oppression and subjugation, that my long-standing fear was that anytime a group got any rights on the page, they would then follow along with the way those have operated for people of color and African Americans in particular, which is people come to my course thinking, oh, well, when I get to equal protection, I may learn that if police officers disproportionately and regularly murder Black people, that might trigger strict scrutiny. That might trigger some kind of interrogation by the courts. But instead I say, well, you're coming to my class for me to explain that the Supreme Court, back when I was pretty darn young, I was a baby, they created a set of doctrinal rules that interpreted the Equal Protection Clause in such a way that I don't have anything for you here. That the Equal Protection Clause doesn't protect me or my family or other Black people from violence by the state, which is what the government is. So what we're seeing now is we have a fundamental right to terminate a pregnancy pre-viability, but it's not subject to strict scrutiny. It's a second-class right. We have now, in the very same term, we had in Obergefell versus Hodges, the court saying that states can't ban same-sex marriage. But as Eric alluded to, in these current cases, but it was all over Obergefell versus Hodges, Justice Kennedy, in the majority opinion, welcoming people to go out and, based on their religious beliefs, convince their fellow Americans that the rights that have been conferred shouldn't be there. And so this court has been telegraphing and inviting impact lawyers to bring cases to them so that people can diminish other Americans' rights by asserting a religious objection. We've been there before. That's exactly what was said about African Americans. You can't sit at the lunch counter because God didn't intend it. You can't marry a white person because God didn't intend it. That is what is highly problematic about this, because we have seen these kinds of arguments before, and this is a court that is not just sitting passively and letting these cases come from the outside. These are justices, I think, are stoking the belief in religious people. And I am from the Bible Belt. I am a Black Baptist from the Bible Belt. So I know what it means to be on a plane and have a pastor just start up a conversation, a really nice, Southern white guy, and say, do you know they're coming for us? Do you know how much they're discriminating against us? And I can't say it's just something he got from his Facebook feed. If you read these opinions, whether it's Obergefell dissents or these opinions, it is the justice of the Supreme Court telling Americans that they're being targeted because of their religious beliefs. And that creates a divisiveness that I think is highly problematic. And so the case that we know that's coming is a case about the rights of sexual orientation minorities to foster children. And that will also be in the context of a religious organization. So the court can choose which cases it hears. The court, of all the cases that are appealed, is choosing to take all of these religious liberty cases, but that's the freedom they want to protect. It's the right to discriminate. It's the civil rights of people based on religion. And the court is serving this up, whether you're a florist, whether you're a baker, the Supreme Court is putting this in front of the American public over and over again. And so it's a danger, I think, for our pluralistic society, because it seems very likely to divide us even further.
No,
Was that Sunshine?
No, I was
No,
just.
I said I had to go on it. I had to submit.
You brought it home. You played. You came back to type, and for the Hammer folks, when we were in person, I think there was always alcohol, and so let me say, when we're back in person in 2032, all the alcohol will be. Sorry, I wanted to show that I am actually the real voice of doom and gloom in the room. Then the alcohol will be on me. In the meantime, I'm sure it's entirely appropriate for me to figure out how to send you some Xanax. So, Eric, to you first, we have a question from Wendy. And she says, what will stop the Supreme Court from holding that all tax money has to be divided up between public function, operation, and a parallel religious one, for example, libraries, by which I take to mean, is this going to go beyond schools to every public program?
Thanks, Wendy. That's a great question. And if the court stays the same as it's constituted, or if it gets more conservatives on it, nothing is going to stop the court from doing that. And that is where the court is heading. This school aid decision doesn't just apply to religious schools. It applies to religious institutions in general. And so I have a theory now. This is not a strong opinion. This is a theory. We'll see how it plays out over the next 10 years. Roe versus Wade, and I'm pro-choice all the way down. Roe versus Wade triggered a series of events that hurt the left, hurt progressives, hurt women, unbelievably. And we can have that debate at a different time. But I think there was a backlash to Roe that was palpable. I think what's happening over the last 3 or 4 years is a backlash to Obergefell. So when the court held that states had to recognize same-sex marriages, Justice Roberts wrote a dissenting opinion unique in his career. He's written strong dissents, but this was his strongest by far. And the last sentence of his dissent in the same-sex marriage case was, the Constitution has nothing to do with the ruling in this case. Quite ironic, given all the cases Justice Roberts has authored where the Constitution has nothing to do with it. But leaving that aside, Justice Alito and Thomas and Roberts, I think they were so angry about Obergefell that not only are they, and Kimberly said this so beautifully, not only are they deciding cases a certain way, but Justice Alito has this habit of dropping paragraphs saying, well, we're deciding this today. But hey, people out there, you should bring the next case because we're going to rule for you in the next case too. Rule for you, meaning rule for religious groups. So I do think that if a state funds certain secular organizations, nonprofits or whatever, and decides not to fund churches who do similar things, there is going to be a lawsuit. And this court is going to find that in most situations, or maybe all, the state is not allowed to say, we don't want to entangle ourselves in religion. And that, Wendy, is a very gloom and doom world, because I believe, as Kimberly does, in religious pluralism. And the government should stay out of religion as much as possible.
And that's that used to be our understanding, right?
Yes.
That it's better for religion, it's better for the government.
Well, Jessica, if I could, that's the irony here, because for for most of our country's history, that was the rule. And then these so-called originalist judges, obviously they're not, come in and make stuff up that out of whole cloth that has nothing to do with the text or history of the Constitution. That's the irony.
Kimberly, this is a question that it's a little bit of policy, a little bit of law, I think. How is it possible that there's nothing in the Constitution that guarantees equal access to public education for all Americans, and yet now we're supposed to pay for private schools with our taxes? That's from Brianna.
Thank you, Brianna. It's a wonderful opportunity to stay on the same message. So there's doctrine. There is a case. It's a case that I tell my students I think it's a super important case for understanding how we have a country where public schools are vary so greatly, and how students don't have access to a quality education throughout the country, which is the court, when given the opportunity to rule that the Equal Protection Clause protects a fundamental right to education, in a 5-4 decision, the court rejected that argument. It also rejected the argument that there should be heightened scrutiny applied when the government treats people differently based on them being low income or low wealth or being poor. That case, San Antonio versus Rodriguez, is the reason that we have the state of public education we have today and why the disparities are so large. The court was given the opportunity to rule that funding schools based on property values violated the Constitution, and to then go on and interpret the Constitution to protect a fundamental right in that realm. And again, by 5 justices, 1 vote, the court opted not to. So the way I can make that hopefully empowering is that the answer to the answer to the question as to why the Constitution means what it means in 2020 is because of who's on the court and the theories they purport to use to interpret the Constitution. We have 6 justices and counting who have some form of, I say it's a regressive approach, an activist regressive approach to interpreting the Constitution, because it's not conservative in my mind. Conservative would be, we stick to the status quo, we don't change stuff. But they have something they say is our approach. And so who controls the Congress, the Senate, the White House, does control the courts. And what Chief Justice Roberts knows and cares about more so than Justice Thomas is that there has been a time in the court's history that where the court was in a showdown with the executive branch and with the Congress. And there were people running for office, running for president, who said, let's add people to the court. Let's add justices to the court. There's nothing in the Constitution that dictates the number of justices on the court. There's nothing in the Constitution that says the justices must have their jobs for life. If the American people want to amend the Constitution and impose term limits and change the number of justices on the US Supreme Court, that too could be done. But you need a groundswell that changes the current composition of both the White House and the Congress, because it can't be just by a vote or 2. It would be that the whole country would want that. But there's nothing in the Constitution that prohibits an interpretation that is grounded in Brown versus Board of Education and reaches that conclusion. And maybe it's another topic. We keep coming up with Hammer future topics. You know, I don't agree with Eric, actually. I'm trying to find something I don't agree with him on, but I don't agree with him on the backlash theory, right? And that's a whole nother thing. But you know, I get it and I'm familiar with it. But as far as the answer to why we are where we are, it is because of the composition of the court and what these justices believe provisions of the Constitution mean. And they're often very counterintuitive. And for those of us who are critical, it's an incorrect interpretation. It really would seem that a properly interpreted equal protection clause would protect some modicum, maybe even a quality education in the United States of America.
Eric, I'm going to let you respond to that. And then I do want to get to Dave and Deborah's question. I think we'll end there. They ask, if religious schools accept public money, does that open them up to some sort of government control or oversight?
Well, that's really interesting question, because there are religious groups like Seventh-day Adventists, who used to refuse government money for that very reason. What Kimberly said earlier is really true. No, the answer to that question is no. By taking public money, they can still fire their teachers in violation of secular laws that they should be complying with. I understand Kimberly was disagreeing with me on the abortion backlash, and that's a 10-hour conversation. But I am wondering, I do think Obergefell really did trigger Justice Roberts. And well, we know he did, because it's the only dissent he's ever written that was so angry and so personal. And what I would like to express to the people who are here, and I know it's going to sound a little maybe pedantic or condescending, but Supreme Court justices are just fancy lawyers who went to Ivy League schools and worked usually for big law firms. The Supreme Court is not a marble palace on a hill. Actually, it is a marble palace on a hill, but we shouldn't treat them that way. They are people, just like you, me, and Kimberly, and people listening. And again, I want to go back to this. If you give any human being unreviewable power for life, it's going to take a person of great judgment and great character not to use that power in ways that they want to use it irrespective of what the law says. So in my view, if the Democrats and somehow capture the Senate and the presidency, either next year, this year, or some other time, they shouldn't make the court liberal, because that will just provoke more backlash in the political scheme. They should disempower the court. We should stop being ruled by 5 elite Ivy League lawyers who sit in Washington, have never been to Oklahoma, have never been to Alaska, don't understand anything about really American working people. And they should be there we should have a Supreme Court to stop clear violations of the Constitution. Otherwise, we have the rule of law of 5 Supreme Court justices. And you don't have to believe me on this. I'll end with this. Justice Brennan, one of the most important judges of all time, served 30 years on the Supreme Court. By all accounts, a great politician while he was on the court. Would ask his law clerks every year, what's the most important rule here? And they would say equality, they would say speech, he would say no. With 5 votes, you can do anything. People show you who they are, institutions show you who they are, and that's who the Supreme Court is.
People tend to feel about the Supreme Court the same way they feel about Congress or the Senate or the president. When they agree with the court's working so well as an institution. When they agree with Congress or the president, yeah, the executive branch is just functioning on all cylinders. And I think it is clear that we have brought up an important topic, which is we really have to, I think, dedicate a space to talk just about the Supreme Court and its utility. But for today, I think you did a heroic job of unpacking 3 of the really complicated cases from this term. In fact, we thought we were just going to talk about Espinoza, which we could have devoted an hour to, but then there were more decisions, and it felt very pressing to talk about what happened in Little Sisters and what that means for women who obtain their contraception through their health insurance plans. What happens in Our Lady of Guadalupe, what that means for Catholic school teachers, Jewish school teachers who want protection from being fired. And of course, Espinoza, which we planned as our main case, talking about what the shape of government programs that provide aid for public schools will now look like. And the fact that, again, the punchline is they have to similarly provide that aid for religious schools, which I just want to emphasize turns on its head much of what we understood for the purpose of the separation of church and state. So with that, we are way over. Kimberly and Eric, it was suitably depressing, it was suitably optimistic, but above all, it was a very, very smart and accessible at the same time. I learned a lot. I know the audience did too. Hammer form, please play us off. We're ready for that music.